The absolute state of defamation law in the United States is that it is a victory simply to be allowed to continue suing for defamation. Viva Frei, Montreal litigator turned YouTuber, and Project Veritas just got an amazingly favorable decision. It's such an amazing decision in that it allows them to continue suing the New York Times for defamation. You may recall that in October 2020, Project Veritas released a bombshell of a report that made certain allegations of the F word, and no, I'm not talking about fortification, as relates to Ilhan Omar. If you don't know what the lawsuit is about, I'll link the lawsuit below so you can go ahead and read it. But bottom line, they allege certain improprieties as relates to ballot harvesting. And after Project Veritas released this bombshell of a report, the mainstream media, being what it is, went after Project Veritas, the New York Times in particular, and alleged that they had made a deceptively edited video and that they were putting out fake information. I am paraphrasing, but that is the gist of it, and there were a few articles in particular that became the subject matter of a lawsuit for defamation that Project Veritas filed against the New York Times. Project Veritas sued the New York Times, 2 of its journalists, Maggie Astor and Tiffany Hsu, and 5 John Does for defamation. But it was a well-drafted lawsuit that subsequently faced a motion to dismiss from the New York Times. Par for the course, the New York Times filed a motion to dismiss on 2 bases. One was the standard failure to state a claim, and the other was invoking anti-SLAPP legislation. Now, we have talked about anti-SLAPP legislation in numerous vlogs, so I'm not going to go over it in any great detail, and besides which the judgment does go over the history of the particular anti-SLAPP statute in question in this particular case. Suffice to say, SLAPP, strategic lawsuits against public participation. It is an unfortunate but well-known reality about the practice of litigation is that it is a game for the rich, and you have had situations of very powerful people with deep pockets who would file lawsuits if only to bankrupt their adversary. SLAPP lawsuits by their nature are intended to silence critics, and so what certain jurisdictions have done is implemented anti-SLAPP legislation, meaning that if one suspects that they are faced with a SLAPP lawsuit, there are certain provisions of law that allow them to have that lawsuit dismissed on its face. In addition to having the lawsuit dismissed on its face, there is also a fee-shifting provision in certain jurisdictions where if you successfully plead that it was in fact a SLAPP lawsuit that deserves to get dismissed, you can have your legal fees covered as well. And the state of New York, where Project Veritas filed its defamation lawsuit, does indeed have relatively stringent anti-SLAPP legislation, which the New York Times invoked in an attempt to have the lawsuit dismissed. And in a tremendous victory to Project Veritas, both grounds of the dismissal being sought by the New York Times were themselves dismissed, and Project Veritas can continue with its action. But the lawsuit is great for Project Veritas not only because it dismissed the New York Times motion to dismiss, but in what it says in the judgment is extremely damning and will send chills down the spine of the New York Times. I don't want to oversell it. Let's just jump into the decision. Supreme Court of the State of New York, County of Westchester, Project Veritas plaintiff against the New York Times Company, Maggie Astor, Tiffany Hsu, and John Does 1 through 5 defendants. Decision and order. Plaintiff Project Veritas, a non-profit journalistic organization, Veritas brought this action against defendants for publishing 5 purportedly false and defamatory articles in September and October 2020, the articles. The articles reviewed a video report published on September 27, 2020 by Veritas, the video, on the topic of, and you can read it for yourselves. The articles include 3 written by defendant Astor, the first on September 29, 2020, titled, quote, Project Veritas video was a coordinated disinformation campaign, researchers say, end quote, which was published online by New York Times. On the same day, an abbreviated version titled, quote, researchers say a Project Veritas video accusing Ilhan Omar of voter was a coordinated disinformation campaign, end quote, was published online by the New York Times. The last was on September 30, 2020, titled, quote, Project Veritas releases misleading video, part of what experts call a coordinated effort, end quote, was published in print by New York Times. And by the way, when it comes to the accusation of coordinated disinformation campaigns, remember what we always say on this channel, hashtag confession through projection, because it looks like that is exactly what the New York Times did themselves. According to the complaint, New York Times, Astor, and Hsu were driven by resentment and journalistic competitiveness after the New York Times, quote, much hyped story, end quote, about President Trump's tax returns was upstaged by Veritas video report, as well as by, quote, their own political biases against Veritas' perceived right leanings, end quote. So they set out to discredit Veritas reporting. Veritas asserts 5 counts of defamation, alleging that defendants published false and defamatory statements, impugning Veritas journalism with reckless disregard for the falsity of those statements. In the instant motion, defendants argue that Veritas failed to adequately plead and cannot demonstrate with clear and convincing evidence that there is a substantial basis in law and fact that defendants acted with actual malice. Defendants reporting on the video was substantially true and corroborated by other media outlets and fact checkers. Veritas failed to allege a false or defamatory statement of fact, and Veritas' extensive reputation for publishing selectively edited videos makes it, quote, libel-proof, end quote. We have done tons of vlogs on defamation on this channel, so we're not going to go over the basics. Suffice to say that when dealing with a public figure or a matter of national importance, one has to prove actual malice of the alleged false statements made. So here the defendants are arguing that Project Veritas did not include sufficient allegations to make evidence of the actual malice requirement such that their lawsuit should be dismissed on its face at this stage. Subsidiarily, they actually argue that their reporting was substantially true, and in support of that allegation, they argue that a number of other fact checkers corroborated their story. And here we get right back into that vicious circle of fake news, that self-fulfilling prophecy where the reporters report on each other's stories, independent fact checkers confirm the truthfulness of those stories, and you just have one big mess of fake news that deems itself to be legitimate because other people have reported the same thing. And in the same vein, if you can believe it, the New York Times actually goes on to argue that Project Veritas is libel-proof because look at how all of the other mainstream media report on them. They all call them names, they all say they're fake news, so they must be fake news and therefore libel-proof. The vicious circle of fake news coming full circle. Project Veritas cannot sue us because they are libel-proof because we've said so many bad things about them that they have to be bad, and they cannot sue us because we said bad things about them.
Try to say that 5 times in a row.
And what did the judge say about it? The judge is having none of it. Now, I am actually reading from the copy that I think was highlighted by Project Veritas themselves, so there is going to be some highlighting. That is not my highlighting, that is from Project Veritas, but I'm going to draw your attention to other passages which I also find relevant. Generally, CPLR 321 1A7 provides that, quote, upon a motion to dismiss for failure to state a cause of action, the sole criterion is whether the subject pleading states a cause of action, and if from the 4 corners of the complaint, factual allegations are discerned which, taken together, manifest any cause of action cognizable at law, then the motion will fail. Here, Veritas' complaint adequately pleaded the 5 causes of action sounding in defamation. In response, Veritas contends that New York Times' own ethical policies, which New York Times publishes on its website, prohibit news reporters from injecting their subjective opinions into news stories published by the New York Times, and thus a reasonable reader would expect a news reporter's statements to be assertions of fact and not opinion. Here, the New York Times is raising what I'm going to call the Tucker Carlson or Rachel Maddow defense, that being, I wasn't making a statement of fact, I was making a statement of opinion. Everyone knows that what they were listening to was a matter of opinion, and no one understood it to be a statement of fact. To which the judge says,
no, no, no.
The court's review of the articles involves considering the full text of the article in which the purportedly defamatory statements were made. Actionable assertions of fact are tightly intertwined with what defendants now characterize as opinion. In part, defendants argue that their statements describing Veritas' video as, quote, deceptive, quote, false, and, quote, without evidence were mere opinion, incapable of being judged true or false. However, if a writer interjects an opinion in a news article and will seek to claim legal protections as opinion, it stands to reason that the writer should have an obligation to alert the reader, including a court that may need to determine whether it is fact or opinion, that it is opinion. The articles that are the subject of this action called the video, quote, deceptive, but the dictionary definitions of, quote, disinformation and, quote, deceptive provided by defendants' counsel certainly apply to Astor's and Hsu's failure to note that they injected their opinions in news articles as they now claim. Likewise, defendants now appear to assert that the promotion of the video was where the deception was. Plaintiff is entitled to try to establish whether New York Times writers were purposely and or recklessly inaccurate, or whether they were inaccurate, sloppy, or something less. Changing your arguments in court or trying to argue sort of mutually incompatible arguments is not going to bode well with some judges, and quite clearly what the New York Times tried to do here did not bode well with this judge. You can see the New York Times sort of sucking and blowing at the same time. They're saying, yeah, we said the video was deceptive, but that was just a matter of opinion. But if it wasn't a matter of opinion, we weren't talking about the video that was deceptive. We were talking about the promotion of the video. Those arguments are mutually incompatible and give an aura of dishonesty in argument, and the judge seems to have gotten a little frustrated with the New York Times argument here. And further in the judgment, the judge writes as follows. Stating that the video is, quote, deceptive, end quote, and stating, quote, without verifiable evidence, end quote, in a factual way in a news article certainly presents the statement as fact, not opinion. Further, the Astor and the Shoe articles could be viewed as exposing Veritas to ridicule and harm to its reputation as a media source because the reader may read the news articles expecting facts, not opinion, and conclude that Veritas is a partisan zealot group deceptively editing video and presenting it as news. Accuse me of bias because, full disclosure, I distrust the New York Times, but that is exactly what the New York Times was trying to do. Anyone reading those articles would not have read those articles as matters of opinion. You would have read those articles as matters of fact, and you would have looked at Project Veritas very differently if you believed those facts. Upon review of the total context and tone of the stories, which clearly disparage Veritas and the video, the court concludes that a reasonable reader could very well believe that the challenged statements were conveying facts about Veritas. The articles certainly could be viewed as being purposely designed to appear that defendants are imparting facts and evidence that Veritas videos were deceptive and Veritas is merely a right-wing political group. The judge then circles back to the vicious circle of fake news. Look at how many other news outlets are reporting that Project Veritas is bad and not trustworthy, so surely it must be true, so it can't be defamatory. The truth is an absolute defense. Attached to defendants' moving papers are over 52 sources describing Veritas' poor reputation for publishing deceptively edited and misleading videos. According to defendants, those sources are not just, quote, some criticism from mainstream and or left-wing media, but rather they come from a variety of reputable sources, including Fox News, the Cato Institute, the Los Angeles Times, Newsweek, the Washington Post, and the Blaze. Far from being, quote, some criticism, end quote, these sources resoundingly describe Project Veritas as, quote, partisan zealots, end quote, with, quote, a history of distorting facts or context, end quote, running cons, end quote, misleading editing videos, end quote, and being, quote, known for its deceptively edited videos, end quote. You gotta love how all of a sudden the New York Times is relying on the Fox News, and by invoking all of the competitors of Project Veritas who say, look how bad Project Veritas is, it means that Project Veritas is bad. While this is a lengthy media list, polling does not decide truth nor speak to evidence, and defendants have not met their burden to prove that the reporting by Veritas in the video is deceptive. Defendants' papers do not conclusively establish that the subject causes of action do not exist, and the court's review of the complaint finds that Veritas adequately pleaded the 5 causes of action set forth in the complaint. Quote, whether a plaintiff can ultimately establish its allegations is not part of the calculus in determining a motion to dismiss, end quote. Defendants failed to demonstrate that Veritas is a, quote, classic libel-proof plaintiff, end quote, whose reputation is so bad that it simply cannot be defamed. That other media sources have criticized Veritas, or that Veritas may have suffered blows to its reputation without more, fails to meet the standard. Then we get into the anti-SLAPP aspect of the judgment, and there is a peculiarity here in that the anti-SLAPP legislation was amended 8 days after the lawsuit was filed, and the question was whether or not to retroactively apply the newly amended provisions of law. The newly amended provisions of law offer even more anti-SLAPP legislations that would have favored the New York Times. They do retroactively apply the newly amended law, but they still dismiss the New York Times request to dismiss on the basis of the anti-SLAPP statute. 8 days after the commencement of this action, on November 10, 2020, the anti-SLAPP law was amended, and under CRL Section 76A, the definition of, unquote, action involving public petition and participation, end quote, was expanded to include 1. Any communication as pertinent here, any writing in a place open to the public or a public forum in connection with an issue of public interest, or 2. Any other lawful conduct in furtherance of the existence of the constitutional right of free speech in connection with an issue of public interest, or in furtherance of the exercise of the constitutional right of petition. And if anyone were looking for evidence to support a bias by this judge, either against the New York Times or for Project Veritas, this would be the section where you might find some evidence of potential bias. The recent amendments by the legislature have turned the original purpose of the anti-SLAPP law upside down. Here, one of the largest newspapers in the world since Abraham Lincoln was engaged in the private practice of law is claiming protections from an upstart competitor armed with a cell phone and a website. Not only does the amended anti-SLAPP law grant protection to a Goliath against a David, but 16 years after the SLAPP law was enacted, a newspaper had never qualified for SLAPP protection for its written articles. Despite this dizzying turnabout created by the legislature, the court agrees that this action meets the amended anti-SLAPP standard as it arises from New York Times reporting on an issue of public interest. Say what you will on the substance of the law, I might suggest that Project Veritas is slightly more than a competitor armed with a cell phone and a website. It is still a David versus Goliath as far as I am concerned. I'm just saying that the oversimplification of what Project Veritas is could be suspect if one was looking for indications of bias. But it is unquestionably a situation of David versus Goliath, even by the New York Times' own evidence, in that you have 52 mainstream media outlets calling Project Veritas the boogeyman. But now that the judge has determined that the anti-SLAPP statutes apply, there is a reversal of the burden of the proof, and it is up to Project Veritas to show that they still have a substantial cause of action. Accordingly, since under CPLR 3211G, defendants have moved to dismiss the action action under CPLR 3211A7 and demonstrated... What's up?
I need my gloves
Why?
because I'm making the ice foot.
You got him?
Bye.
Okay, see you soon. Where was I? CPLR 3211G shifts the standard burden for a motion to dismiss from defendants to Veritas to, quote, demonstrate that the cause of action has a substantial basis in fact and law, end quote. And with respect to the substantial basis in fact and law of Project Veritas' lawsuit, this is what the judge has to say. Veritas argues that not only does the complaint allege that defendants had knowledge of the falsity of their defamatory statements at the time of publication, but it pleads detailed facts showing the presence of literally every, quote, hallmark of actual malice recognized by the law, including setting out with a preconceived narrative, being motivated by ill will and bias, failing to contact obvious sources of information, relying on biased and non-credible sources, violating journalistic standards, and refusing to retract. Veritas alleges that it has far exceeded that standard by pleading overwhelming circumstantial evidence of actual malice, including that, and you can go on and read it for yourselves. Alright, so I have been summoned to go build a snowman, but what you should take away from this is it's not just the order in and of itself that is extremely important in this judgment, it's what the judge actually says in the judgment. Above and beyond dismissing the New York Times motion to dismiss on both grounds, the judge has some pretty damning things to say based on his appreciation of the evidence at this stage of the proceedings. He is not making any determinations on the merits of the claim, and he is specifically forewarning Project Veritas that they have a high threshold to satisfy in order to succeed on their claim, but he has some very damning things to say about the New York Times. And so if I am the New York Times, above and beyond potentially taking this decision to appeal, I am reading the words in this judgment and I am planning for the future and possibly looking to settle this lawsuit, if at all possible. All right, and with that said, I hear footsteps looming in the background. If you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
Tina, you fat lard, come get some dinner.
If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. We've got merch. Politics ruins everything, and that is my... Yes?
Can you help us make the ice foot?
Yada, 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 and now you know your vlog. Peace out. Booyah!